Imagine living in a country where your rights are protected not just by law but by powerful tools that let you challenge even the government when something feels unjust. In India, that power lies in the concept of writs, a set of legal remedies that citizens can invoke when their fundamental rights are threatened. Through Articles 32 and 226 of the Constitution, the Supreme Court and High Courts act as guardians of justice, empowered to issue five special orders or writs that can free the unlawfully detained, stop wrongful official action, correct judicial overreach, or even question someone's right to hold public office. These writs aren't just legal procedures, they are the soul of a democratic India, making sure that no one, not even the state, is above the constitution. Let's understand these writs. Under Article 32 for the Supreme Court and Article 226 for the High Courts of the Indian Constitution, both the courts have the power to issue writs for the enforcement of fundamental rights, and in the case of High Courts, even other legal rights. Article 32 is often called the heart and soul of the Constitution. Article 226 is broader than Article 32 as it covers not only fundamental rights but also any other purpose, that is, legal rights. Which are the five writs in India? The first writ is habeas corpus, which means to have the body. The purpose of habeas corpus is to protect individual liberty against illegal detention. If someone is detained without legal justification, the court can order the authority to produce the detained person and justify the detention. For example, if the police detain someone without any charge, a friend or a family member can file for habeas corpus. The next is mandamus, which means we command. The purpose of mandamus is to direct a public official or authority to perform a duty they are obligated to do. When a government officer fails to perform a mandatory duty, mandamus can be used. But mandamus cannot be issued against president, governors, or private individuals, only against government officials. The next writ is prohibition. The purpose of prohibition is to stop a lower court or tribunal from exceeding its jurisdiction or acting contrary to the law. It is issued by the high courts to the lower courts, higher courts to the lower courts. For example, if a civil court takes up a matter outside its powers, a prohibition writ can be issued. The next writ is certiorari, which means to be certified. The purpose of certiorari is to quash an order already passed by a lower court or tribunal that had no jurisdiction or which violated the law. It is different from prohibition in that prohibition stops the act before it is done, but certiorari quashes it after it is done. And the last and final one is quo warranto, which means by what authority. The purpose of quo warranto is to question the legality of a person holding a public office. If someone is appointed to a public post illegally, the court can ask them under what authority they hold that particular position. These five writs, which are powers given to our judiciary, the Supreme Court and High Courts by the Constitution of India, grant the judiciary and give them tremendous powers and also help them ensure that justice is served and that fundamental rights and liberties of people are protected. They help the judiciary in their work of dispensing justice and making sure that the constitution is properly enforced. We as citizens have the power to approach courts and make use of these writs if we see anything wrong going on. Thank you so much for listening.